Welcome to the Loudoun County Bar Association, the Arlington County Bar Association, the Virginia Employment Lawyers Association, and the Metropolitan Washington Employment Lawyers Association's March webinar, The Virginia Human Rights Act Practice in 2024. I'm Scott Oswald. I am MWELA's Bench Bar Committee Chair and your moderator for today's program. Before we begin, Amanda Swart from the Loudoun County Bar Association, Bill Turner from the Arlington County Bar Association, and Paul Falabella from the Virginia Employment Lawyers Association have introductory remarks for us. First, Amanda Swart from the Loudoun County Bar Association. Amanda?
Thank you, Scott. Good afternoon, everybody. As Scott mentioned, my name is Amanda Swart, and I am the president this year of the Loudoun County Bar Association. Loudoun County Bar Association, as it sounds, is a voluntary bar association for attorneys who practice in Loudoun County. Our goal is to facilitate the relationship between attorneys who practice here in Loudoun and our General District Court, our Juvenile and Domestic Relations District Court, as well as our Circuit Court, to our bench, and make that relationship smoother for everybody, as well as to really serve the needs of the attorneys in Loudoun County. So we are happy to sponsor this event with MWELA, and hopefully our members who have joined the call get some value from it.
Amanda, thank you. Next to Bill Turner from the Arlington County Bar Association. Bill?
Good afternoon, everybody. As Scott mentioned, my name is Bill Turner. I am the current president of the Arlington County Bar Association. I wanted to talk just briefly about some of the membership benefits to joining the bar. We offer reduced rates on various CLEs and other programs. I'll highlight one that we do usually around the Columbus Day, Indigenous Peoples Day. It's a mock jury trial that live streams juror deliberations. It's a 7-hour CLE credit for only about $180 for members of the Arlington County Bar. And a lot of our members get almost all of their credits for every year attending that event. We also have a fair amount of social and networking events that we do, and these are typically free. And we usually have a very good turnout from the bench. In fact, this Wednesday, we're having a bench bar at Four Courts, right next to the courthouse. Four Courts bar and restaurant from 4 to 6 p.m. Again, that is Wednesday, March 13th. And we're always looking to add members, especially in leadership positions. So join now at arlingtonbar.org. Thanks, Scott.
Bill, thank you. And now to Paul. Paul?
Thanks, Scott. Good afternoon, everyone. I am a plaintiff's employment lawyer in Richmond with Butler Curwood, and the current president of the Virginia Employment Lawyers Association. We are a group of plaintiffs' employment lawyers from around the state and are the Virginia affiliate of the National Labor Employment Association, NELA. We have members in all parts of the state, Roanoke, Richmond, Hampton Roads, Northern Virginia. We've got a really excellent and active listserv dedicated to discussing issues related to plaintiffs' employment practice. We host CLEs throughout the year, typically by Zoom and in kind of a brown bag format during lunch. We've got an upcoming CLE this year with Darren Calhoun, who's the director of the Richmond EEOC office. So if you're interested in joining, you can go to our website, which is there, or reach out to me directly. We'd love to have you. Thanks, Scott.
Paul, thank you. And now to our participants in today's roundtable. The Honorable David Oblon is a circuit court judge on the Fairfax County, Virginia Circuit Court. Prior to joining the circuit court, Judge Oblon served as a substitute judge in the General District Courts for almost a decade and served as a commissioner in Chancery. Christine Johnson is a senior assistant attorney general in the office of the Virginia Attorney General. Christine heads the Office of Civil Rights for the Commonwealth of Virginia. The office has jurisdiction over state law employment discrimination claims in the Commonwealth. Bethany Ingle is a shareholder at the law firm of Littler Mendelson. Bethany represents employers in employment discrimination disputes. Josh Erlich is the founding principal of Erlich Law Office. Josh represents employees in employment discrimination disputes. I'll take your questions throughout the discussion portion of today's program. Just use the Q&A button located at the bottom of your Zoom screen. Let's begin with a primer from Josh Erlich on the Virginia Human Rights Act. Josh?
Good afternoon, everyone. We've had a law called the Virginia Human Rights Act for quite a while. But up until a few years ago, it was sparsely used for a variety of reasons. It just wasn't a particularly strong law. And those of us that did employment discrimination work very rarely brought cases under it. It was almost exclusively a federal practice. Since the Virginia Values Act and then a couple of subsequent tweaks to the law, the Virginia Human Rights Act has become a much more viable option for employment discrimination cases. And just to note, the Values Act also expanded the Human Rights Act outside of the employment context, but we'll only be talking about employment today. Unlike what we had previously, it's now a pretty straightforward process to get into both general district court and circuit court in the courts of the Commonwealth. And as we'll see in the coming slides, the law essentially expanded almost everything that the prior law did. If you could go to the next slide, please, Lars. Okay. So as to who is covered, generally speaking, if you have more than 5 employees, or if you're a business with more than 5 employees, you're covered under the Act. There are ambiguities as to how the coverage works for certain kinds of cases between 6 employees and 15 or 20 employees, depending on the cause of action. But generally speaking, more than 5 employees, the business is covered, and the protected classes are pretty broad. We've got race, color, and religion, national origin, sex, and pregnancy, all very normal at the federal level as well. This law also specifically mentions childbirth and related conditions, age, marital status, and on and on and on. A few of the places that we'll briefly touch on where the protected classes are particularly broad, there's some good litigation, at least from my perspective, in Virginia, that folds hair discrimination into race discrimination. So, it's not infrequent that someone will tell us that, they were hired because they were fired because they had dreadlocks, or because their boss felt that their hairstyle was unprofessional, something along those lines. Those things can explicitly be considered race discrimination in Virginia. Lawrence, if you could go to the next slide. Previously, the Virginia Human Rights Act was pretty limited to termination. Now the law explicitly lays out other adverse employment actions that are covered. Y'all can see on the bullets here, but broadly speaking, the sort of scope of things that we consider adverse actions or materially adverse at the federal level, most or all of them are going to be covered under the new law or the updated law. Now, the thing to flag with this, and you'll see it at the bottom of the slide, is that you only have a termination claim if the business has between 6 and 14 employees. These other things that are not termination, the concept of a hostile work environment, those things, I should say a hostile work environment that does not lead to termination specifically. Those things just are not covered right now. Now, we'll also discuss in a little bit, there's some pending legislation that might change some of these things. We're not sure what's going to be signed and what isn't signed, or what isn't going to get signed, but we'll cover that in a minute. Lawrence, if you can go to the next slide. Okay. I specifically included this slide and the next slide on pregnancy and childbirth related conditions because the law that we have is very aggressive in these places. There is there are some exceptions, or at least some outs for an employer that we'll discuss on the next slide. But I would like everyone to see this list of required accommodations. The law is very aggressive on this. It's 2.2-3909. It is a whole subsection of the law specifically devoted to pregnancy-related accommodations and childbirth issues. So more frequent and longer breaks, assistance with manual labor, a private location for pumping, all of this stuff is not implied from the fact that pregnancy is a protected class, but is in fact laid out in the law specific. Lawrence, if you could go to the next slide. The only thing in the law really that that provides an exception is a hardship exception. And this hardship exception is, it remains to be seen what the courts will do with it, but these are not particularly broad. By and large, I think it is going to be not dissimilar to undue hardship under the Americans with Disabilities Act and related laws, but at least to my understanding, I don't think we have almost any case law defining this. And that is true of much of what you'll find in the Virginia Human Rights Act. Lawrence, if you go to the next slide. I'm sure we'll be talking about this more later, but the statute of limitations under the Virginia Human Rights Act is unclear at the moment, at least from my perspective, right? The VHRA itself does not include a statute of limitations at all. Here we have listed the regulatory statute of limitations that is the only place where you will find the 180-day and 300-day limits. I think Ms. Johnson's probably going to speak about this a little bit later as to how her office interprets this, but at least as a matter of the text of the statute, there is no statute of limitations, and the regulation that we have is from the pre-Virginia Values Act period. So it's not entirely clear to what extent it applies in the current climate. But as I said, I'm sure we'll talk about that later. Lawrence, if you could go to the next slide. One of the other issues that has been a real, there's been a lot of back and forth over this, is how notice of right to sue and closeout letters work under the Virginia Human Rights Act. So the law, by its terms, pretty explicitly says that you need a closeout letter from the Office of Civil Rights. And the courts have been inconsistent on whether getting a notice of right to sue from the EEOC is effectively the same, or whether you need a specific closeout letter from the Office of Civil Rights. I've put some citations here for different perspectives that we've got from the court on this. This is also something that is subject to some of the legislative fixes that may or may not get signed. I wanted to also include at the bottom here, Moore v. Copper Roads Shared Services, a very recent Fairfax case that determined that the plaintiffs don't even need to file with OCR to bring a VHRA claim. I have no opinion on whether that is rightly decided, but the scope of perspectives and what you will get from different case law on this is very broad right now. And hopefully the legislative fixes just sort it out. But if this ends up being a case law issue, it's going to be a while before this is sorted out in a way that we can rely upon. Lawrence, if you can go to the next slide. Another issue that is up in the air right now, but has a legislative fix that is that we'll talk about in a moment, is sovereign immunity. There is competing case law right now on whether VHRA claims can be brought against against entities that can invoke sovereign immunity. So whether that's the state, counties, what have you. And we just don't have a good answer for it yet, but be aware of that. And consider that in when you're considering your litigation risk, that you might be limited to your federal claims if you're pursuing a sovereign. Lawrence, can you go to the next slide? Okay, so these are the three bills that are most relevant that are still pending. All three of these bills are technically still alive. I need to check my. I didn't realize I didn't have this in these notes, but two of them, I think House Bill 782 and Senate Bill 570, but I'll double check that, have been passed by both chambers and are being sent over for signature or veto, and we'll see what happens. And some of the language in these three bills are duplicative, so it's a little bit hard for us to know how this is going to work out, especially when we don't know if the bills are going to be signed at all. But soon we will either have a bunch of these problems solved or, another year to work out the case law. And something that has happened here, that's happened in a lot of places, is, this law was passed right after COVID started, or the Values Act was passed right after COVID started. And for a law that is now 4 years old, we just don't have a lot of case law on it. You would expect that at this point, after 4 years, some of these things would have just been sorted out by the courts. But because of the delay in litigation, we just don't have a lot of answers yet. Lawrence, if you go to the next slide. Okay, and the final thing, and one of the reasons why the VHRA is considered so useful, especially from the plaintiff side of the bar, is that it just does not have the limitations that the federal claims have on damages. So what the law says, and this is directly from the law, is the court may award unlimited compensatory damage. Generally speaking, under your federal claims, you'll have a $300,000 cap on compensatory damages that is separate from your economic damages. Under the VHRA, it considers economic damages as part of your compensatory damages, but does not put a limit on them at all. That, combined with some of the other advantages to being in state court that I'm sure that we'll talk about as this session goes on, makes this a very attractive law for plaintiffs to use, but it is within the context of knowing that there's also all of these open questions that it's hard to proceed under the VHRA with some of these open questions in certain circumstances, especially if you're dealing with a sovereign or something like that. Scott, that is my last slide, so I'm going to pass this back to you.
Okay, Josh, thank you for that primer. We're grateful for it. Let's begin the Q&A portion of our program with a discussion of how the Virginia Human Rights Act is enforced. And Christine, I'd like to begin with you. Take us on a tour of your office. How's it structured?
Sure, I'm happy to, and thank you for the opportunity to speak to you all today. I've been looking forward to it. Our office is made up of about 5 attorneys and 4 investigators, and we have multiple support staff and intake. And we handle matters that expand past the employment law enforcement. We enforce anti-discrimination laws under the fair housing context, voting rights, and law enforcement. So we have jurisdiction over other statutes beyond the Virginia Human Rights Act.
Got it. Let's talk about how to file an administrative complaint with your office. What advice do you have on how to use the online platform to file a complaint of employment discrimination with your office?
Well, we still receive our complaints in all sizes, shapes, and forms. We get them by fax or mail or email, but we are definitely trying to shift to the online platform. So that should be provided in our materials. We have, it's on the Attorney General's website. Currently it's under programs. I think they're shifting it over to a more prominent place, so that you can, the individual, either the attorney or the complainant, can file a complaint for discrimination online.
And if a complainant uses the online complaint portal, does the portal issue a receipt so we have a proof of the fact that we filed it with your office?
You know, that has not been set up yet, and we're still developing the platform. But it goes to us. I mean, I see it on my inbox on the platform every day. So, you know, we receive everything that comes in.
Got it. And then do you acknowledge the receipt of that kind of complaint?
Yes, you should be receiving, as a matter of course, as in the past, a letter from our intake person saying, we received your complaint. We're going, you know, we'll get back to you as we process it. Then starts the process of reviewing whether an investigation is going to be opened or whether we will defer it to the EOC. Between those two choices, you'll receive notice of those.
Got it. Let's take our first question from the audience. Does OCR still require a wet signature on a complaint form? Christine?
Very good question. That's a regular practitioner. You know, that we do not require that on the online complaint form, because the online accepts the digital signature or the typed signature. So we are moving away from that. We still need a signature on the complaint form. If you're going to submit it as a paper, then we request it to be a real signature, which is one reason why you might want to go online and sign up.
Got it. Okay, your office is now issuing shorter, more streamlined notice of charge filing. Tell us about that.
Yeah, and I'll explain that in the context of two things that we've shifted in the last couple of years. As Josh indicated, the courts have been giving mixed signals on whether a complainant in Virginia courts needs a right to sue, either in federal or state courts. And when I came into the office, the policy of the previous Attorney General was that the office thought that the courts would accept the EEOC right to sue. When I came in, became clear that was not happening. So under Attorney General Miyares, we changed that position, and we began issuing notices of right to sue from the Office of Civil Rights in the fall of 2022. Since that time, when I announced it to the plaintiffs and defense bar and to VHRA and to the Labor Employment Group of the BBA, since that time we've received many requests for notices of right to sue, and we've received over 120 in 2023 alone, and we issued over 150. So we're proud of that change and our accomplishments there. Relatedly, after that issue was dealt with, this change, another policy change occurred more recently in the fall of 2023, where cases were not being responded to. And so we began to issue shorter, more streamlined notices of charge, more along the order of the EEOC notice of charge, so that the complainant will know that we received the complaint, and the respondent will know that the complaint has been submitted to the office. This will help us meet our obligations under our FEPA agreement and the work share agreement with the EOC, and enable us to process the complaints more quickly. So we hope to, that started this fall, and we hope you'll be seeing those in your inbox when you submit complaints.
Let's take another question from our audience. Is the work sharing agreement that you have with the EOC with the DC field office, the Charlotte field office, some other field office?
Our work share agreement is with the EEOC. We are under the Charlotte field office. The Richmond office in the lower part of Virginia is under the Charlotte district. The Washington field office has Northern Virginia. So we are under the Charlotte district. That's our liaison, our contact. But our FIPA agreement is with the head HQ, EEOC.
Got it. Okay, let's turn to the administrative deadlines for filing a complaint. And Josh kind of took us through Virginia Administrative Code 45-20-30. As the Act doesn't contain any deadline by which a complainant must file an administrative complaint, tell me what the rationale is for the 180 and 300-day filing deadlines in the Virginia Administrative Code.
We have to start from the Enabling Act for the Office of Civil Rights, and that's under Section 2.2-522. That Enabling Act for the office states that all complaints must be submitted within 180 days. We've operated under that statute in tandem with the Virginia Human Rights Act for decades. This is kind of a leftover from, when the Council of Human Rights was under the governor's office, and before it was moved into the Office of Attorney General. Since 1997, however, the statute itself specified the regs specified a 300-day statute of limitations. So in 2017, the regs inserted the 180 days. In 2020, the regs were amended again to recognize a 300-day. So the way we apply it, which is probably what you're wondering, is looking at whether the claim is solely under the Virginia Human Rights Act or under both the Virginia Human Rights Act and the federal claims. And that's what the practitioners have to distinguish. If you are filing a federal claim, a claim that falls under Title VII or the ADA or the Age Act or GINA, and that is in tandem with a claim that also falls under the Virginia Human Rights Act, then we will recognize the 300 days. That's for both the federal claims under a FIPA agreement and under the Virginia Human Rights Act. The Reg 45-2030 states that a complaint alleging a violation of federal statutes governing discrimination in employment that also falls under the Virginia Human Rights, the Act, shall be filed with the division not later than 300 days. So we recognize Virginia Human Rights Act claims that also fall under the federal act with a statute of limitations of 300 days, with the caveat that that hasn't been weighed in on by the courts. So that's how our office recognizes it, and we are protecting the rights of individuals. We get claims of complaints of discrimination under other bases that only fall under the Virginia Human Rights Act. For example, veteran status. It's not a protected class under the federal statutes. So in that regard, we would apply the 180-day statute of limitations.
Got it. And if, let's just say as an example, a charge is filed with the EEOC, is it automatically considered filed with your office simultaneously, consistent with the work sharing agreement?
So in order to answer that question, we have to really be careful with our terms. When a practitioner submits or a complainant, files a complaint with the EEOC or the Office of Civil Rights, both agencies do not recognize it until it's perfected. So a charge filed with the EEOC has to be perfected. If the EEOC receives an inquiry that doesn't get perfected, we never hear about it. If the EEOC receives a complaint of discrimination that doesn't meet the Holowecki standards, isn't complete, isn't signed, we never hear about it. So if you file a complaint in the EEOC and it's not perfected, we won't know about it, and vice versa. If we receive a complaint that doesn't state a basis, isn't legitimate under the Holowecki standards, the EEOC is not going to hear about it. So the term dual filed only means when one of the agencies recognizes the complaint, perfects it, and then advises the other agency through our internal communications that this complaint is adequate, it meets the Halaweki standards, and now we're notifying you that we have it. And that is what dual filing means. I think there's a lot of misunderstanding out there, and it's not anybody's fault. Well, any of our practitioners' fault, but because it's not, dual filed is not defined in the statutes, the regs, or even the FIPA agreement if you've tried to look. So that's difference between submitting a complaint either to the EEOC or OCR and having a complaint perfected. Once a complaint is perfected, then the agencies notify each other so that we don't track on dual investigations, so we don't duplicate one another's work. And whoever gets the complaint first kind of has first dibs on it.
Christine, thank you. I want to come back to some of those topics a little later on, but I want to turn to practicing in Fairfax County Circuit Court. And Josh, you mentioned the advantages of the statute. From your perspective, what makes Fairfax County Circuit Court a good place to file an employment lawsuit?
Absolutely. So the two biggest things from my perspective are, one, in Virginia courts, as most folks know, we don't meaningfully have a summary judgment practice. The vast majority of employment discrimination cases that get to summary judgment, and they are often disposed of on summary judgment one way or the other. But it's hard to get to a trial in federal court, especially the Eastern District. There are just very few civil trials over the course of the year, much less employment discrimination trials. So in Virginia, if you file in the state court, if you don't get dropped on the demur or a plea and bar, the early stage motions, you're going to get a trial. And then there are advantages to trials in Virginia state courts. This will likely come up later with Judge Oblon, but we have a much more interactive voir dire process in state court as opposed to voir dire in the Eastern District, which is very removed, very judge run, and it's very hard to get any input in it at all. Fairfax is a great place to be because there are a lot of well-established rules, especially those of us that are accustomed to circuit court or accustomed to federal court. There are some circuit courts in the Commonwealth where it can be a little bit more of the wild, wild west, a little harder to figure out exactly what the procedures are. One nice thing about Fairfax is the procedures aren't always exactly what you want, but they're there, and it's relatively easy to navigate them. So those are the big things.
Josh, thank you. Judge Oblon, I'd like to bring you in at this point. Tell us about the common mistakes that you see parties make in filing a lawsuit in Fairfax County Circuit Court.
The most common mistake that I see is when you have lawyers who don't work their case backwards. And by working backwards, I mean, start with the conclusion, start with the jury instructions, and then do your discovery with that in mind, write your complaint with that in mind. And that way you are able to survive the only effective way of eliminating a case in Virginia early on, which is the demur. When the court gets a demur, all the judge is looking at is, did the plaintiff plead facts that support each of the elements of the cause of action? If the answer is yes, then the demur is overruled. If the answer is no, then there's an opportunity to replead, to amend the complaint. But if you start at the end and simply go to the jury instructions, which list what the elements are of your cause of action, and then just make sure that you've listed each of those with some one or two facts for each element, you'll survive demur.
Are judges specially assigned to lawsuits in Fairfax County Circuit Court?
Not usually. There are exceptions. That exception is if you have a particularly complex case, or you have a case that is going to be involving a particularly large amount of motions practice, then some of those cases will get assigned to a specific judge. And the way to make that happen is to write a letter to our chief judge. Currently, that's Judge Penny Ascarate, and write a letter to the chief judge, and ask for a specific assignment. Here's a tip for practitioners. If there's a particular judge that you want to hear the case, do not include that judge's name in your request to Judge Ascarate. If you specifically request a judge, you're almost certain not to get that judge. And so there's a tip that could be worth the price of admission for the CLE.
Thank you very much. Let's take a big picture moment of the VHRA. Josh, you talked about some of the advantages of the act itself. I want to just touch upon a question that we got from one of our audience members. How does the VHRA damages interact with Virginia Code 8.01-38.01, which caps punitive damages at $350,000?
To the best of my understanding, because there are several types of remedies listed in the Act, one of them is punitives. To the best of my understanding, that punitives award would be subject to the cap, but that cap wouldn't apply to any of the rest of the damage.
Thank you. Bethany, I'd like to bring you in at this point. One of my management side friends told me that in the wake of the Virginia Values Act amendments to the Virginia Human Rights Act, it now feels like litigating under California's Fair Employment and Housing Act. What do you think?
So I would have to agree, and I've actually gotten this question from others as well, if it now feels like we're practicing in California. And I do think it gives me a little bit more in common with my colleagues at Littler who are out on the West Coast with the uncapped damages. And I think just the lack of clarity in the case law that we're seeing, there is that element of unpredictability. You know, I think we got comfortable in federal court. You know, we've got a plethora of case law in the Fourth Circuit. We, felt, comfortable going into summary judgment. And now knowing that we've got to get more comfortable in state court, we're likely not going to see summary judgment, not being able to use depositions in summary judgment briefing, that we're going to have to focus on the case more at the beginning stage, the demurrer, which I don't mind so much. I do like motions to dismiss, early motions practice, demurrers, but it does give it that element of unpredictability. And I do think that we feel more like our colleagues out in California now.
Judge Oblon, let's touch on early dispositive motions if we could. Tell us how early dispositive motions are assigned and heard in Fairfax County Circuit Court.
The most common dispositive motions that the court hears are demurrers and pleas in bar. A demurrer is where you're alleging that the complaint itself doesn't set forth the cause of action. And a plea in bar is a defensive pleading where there's one discrete issue that resolves the entire case. And that plea in bar discrete issue cannot be the main claim. I mean, so you can't bring a case of wrongful termination and say as a plea in bar that that the lawsuit should be barred because there was no discrimination. That's a plea to the general issue, and that wouldn't go forward. A more common plea in bar would be statute of limitations, sovereign immunity, things like that. And as far as how they're assigned to individual judges, we have every Friday is a Friday motions day. And most of those Friday motions day will be civil for any individual judge. And we have a coordinator who spreads out all of the motions so that every judge has roughly the same amount of workload and variety of cases. And so on any given motion day, I'll have between 20 to 30 motions, most of which are close calls and complex. Otherwise, they wouldn't be on the motions docket. They would be resolved by the parties. And of those, I'll have about 3 or 4 demurs or plea and bars or combination of those. And they're distributed relatively evenly. But you have to keep in mind that in Fairfax, because cases are not assigned to individual judges absent the procedure that I just mentioned, different judges are going to be hearing and adjudicating different parts of your case. So you could have one judge hear your demur, a different judge hear your plea and bar, a third judge hear a discovery dispute, and then a fourth judge actually hear the trial. And that is just something that you should just know about as part of the Fairfax procedure. There's a efficiency to it. It means that the judges in Fairfax are always employed. We're always on the bench because we don't have dead time that would happen if a case were specifically assigned to an individual judge. But there are, I'm sure, advantages and disadvantages to the litigants themselves by not knowing who your judge was or having the judge not doing all parts of the case.
So with 20 to 30 motions on your Friday motions docket, how do you come to speed on all of those issues in the short amount of time that you have?
I'm not going to lie to you. It's a lot of work. But the judges signed on for this, and so we're happy to do it. Each judge will get the Friday docket the Monday before that Friday. And we limit litigants ordinarily to 5 pages for each side for the briefs. And so that helps to manage the scope of what we have to read. But we'll get all of those briefs on Monday, and most judges will spread out the work throughout the week. We'll come in early, we'll stay late to do reading because Monday through Thursday, we have our trials, and there's really no time to read and prepare for motions day during that time. So I'll set out and docket for myself privately, morning time or afternoon time, to do a handful of the cases so that by Friday, I'll have read all of the briefs and I'll have preliminary thoughts on what the resolution for each will be.
Josh, while these motions, these initial motions are outstanding, the demur, the plea and bar, maybe a motion craving OYER, is discovery proceeding even when those motions might be pending?
It is. Unlike federal court, you can start discovery immediately in Virginia, and that is another thing that is relatively plaintiff friendly to be able to start your discovery process before the dispositive motions have been ruled upon. Okay.
Christine, I'd like to bring you back in at this point and talk to you a little bit about, first off, sovereign immunity. I recognize that this will potentially be resolved in the pending legislation, but right now, what is your office's position as to whether the Virginia Human Rights Act applies to the Commonwealth of Virginia and its instrumentalities?
So the position of the office is that the Human Rights Act does not apply to the Commonwealth and its instrumentalities. That was ruled on by the Court of Appeals in Fogelman v. the Commonwealth in 2023. We have also taken the position that it does apply to political subdivisions. That's a different view. There's case law where, for example, public schools have a different immunity than University of Virginia. So this office, the Office of Civil Rights, and under Attorney General Miyares, has taken the position that school boards are subject to the Human Rights Act. We have issued reasonable cause findings against them, conciliated matters with political subdivisions, and applied it against public entities, but not the Commonwealth.
Got it. The Virginia Human Rights Act, does it apply to individual corporate employees as well as the corporate employer itself?
We have defined, we approach the definition of employer as per the Act, and patterning ourselves where appropriate after the federal, definitions. But there's no case law on this, so that's developing. In the Office of Civil Rights and its capacity on behalf of complainants certainly would interpret that maybe more broadly than a defense would. So we'll have to work that out.
So what I'm hearing from you is that to meet the administrative filing requirement, if an employee cites as the respondent both the corporate employer and an individual, you'll accept the intake form.
We would. I mean, we receive complaints in all forms of sophistication. So we would accept the complaint against an employer, which is defined as employing someone. So it would be both the corporate or the individual.
Bethany, when an employee names an individual defendant, so in addition to the company, an individual defendant, does that facilitate settlement? Does it complicate, hinder settlement? What's your view?
It just depends. I think so. This is can complicate defending a client, particularly if there's any sort of conflict of interest with an individual manager. And typically there's not. Of course, we have to get waivers in order to proceed with defending the corporate entity and any sort of individual manager that's been named. But it does add a layer of complication there. I've seen it used in order to try to defeat diversity jurisdiction in claims here where there are only state law claims, only VHRA claims brought. And so that is a layer of complication there. And I think because, we're dealing with an unsettled area of law here with the VHRA that we're discussing today, if the claim can't be removed because there is this to state or to federal court, because there is this individual defendant and there's not complete diversity and we're stuck in state court, there does present an opportunity, I think, for settlement to perhaps seem more appealing because there's not, as good of a likelihood we'll get summary judgment in state court or summary judgment at all. We're headed to trial if we can't get rid of some of the claims earlier on in the action.
Let's talk about some of the claims that you see in conjunction with claims under the Virginia Human Rights Act. Do you ever see employees including a Virginia reprisal claim under 40.1-27.3 or a Bowman wrongful discharge in violation of Virginia public policy claim along with their Virginia Human Rights Act claim?
Yes, definitely seeing that more often where the underlying violation of the law under the reprisal claim is the act of discrimination itself being the violation of the federal law. So definitely seeing these more. I will say this is a newer practice. And so, I've not seen how this has played out in my own practice at summary judgment. But yeah, we're definitely seeing more of these claims, both the Bowman and the reprisal claims being brought together, the discrimination claims.
Scott, may I circle back to the person question and the coverage of the employer?
Sure.
I just want to direct our listeners to the code, the regulations to the VHRA, which define person consistent with 1-230 of the code. So regulation 145-2020 defines that way. An employer means a person employing 15 or more employees. So that expansive definition of either an individual or corporate entity is already baked into the statute and the regulations. And so, I would be aware of that.
Thank you. Hey, Josh, causation is a constant source of our attention in employment cases. Has there been any guidance from the courts on what the causation standard is under the Virginia Human Rights Act? We're talking about a contributing factor, motivating factor, but for, Any guidance at all?
So I don't believe that we have an explicit standard from the court yet. But in addition to not having that, for anyone who's done employment cases, we also don't have burden shifting as a matter of law, right? Most of us are pretty familiar with the McDonnell-Douglas burden shifting framework, and involving pretext and what have you. And it is still an open question about whether, that is going to come into Virginia law. And certainly it is not part of the case law yet. And if that becomes an appropriate rubric to evaluate employment discrimination claims or employment discrimination claim, it's going to have to come from case law, and we don't have it yet.
Got it. I'd like to turn back to Christine for a moment, take one of our questions from our audience. If a complaint is filed with the Office of Civil Rights and OCR subsequently refers it to the EEOC, is the plaintiff entitled to a right to sue letter within 180 days after filing with OCR, or 180 days after the date that the EEOC takes over? Christine, what do you think?
That's a good question, because as I described before, a matter is not dual filed until one agency advises the other that the complaint has been perfected. But that is separate from the receipt date of whatever is submitted, the complaint, a charge, fully drafted by an experienced attorney or handwritten by a pro se. The date that is submitted to the EOC or to OCR is the date for the tolling of the statute of limitations. So we have to step back and say, okay, OCR receives a complaint on March 27th. We take some time to review it, and then we tell EOC, okay, we're going to defer it over to you. We're not going to investigate this. You can have it. After 180 days, after March 7th, the date that the complaint is submitted to us, that's when the individual can ask for the notice of right to file a civil action from OCR. Yes.
Okay, I want to come back to that in just a minute. Josh, I want to pose this question to you, again from the audience. Are you separately, Josh, filing charges with both the Virginia AG and the EEOC, or are you relying on dual filing with a single agency and requesting a right to sue from VA if going to circuit court? What do you think?
The best practice at this point, in my view, is to file separately with both. The Form 5 charge of discrimination for the EEOC at the top has a fill-in box for cross-filing, but I am not confident that those complaints regularly get cross-filed when you do it that way. At OCR, and Christine can speak to this more in more detail, but our experience with OCR is that those complaints do get consistently cross-filed, because it is very common that OCR sends things out to the EEOC if there's EEOC coverage. So that seems a little bit more consistent, but still, best practice is to file with both. And Scott, if you don't mind, I just very quickly wanted to follow up on something Christine said. I wanted to ask her, we have received letters from your office saying that a charge is being held in abeyance. You mentioned receipt dates, dates of perfection. Would you mind clarifying a little bit what in abeyance means in this context? And if from your office's perspective, if the charge is in abeyance, the statute's been told?
So fair question. That is a practice that preceded my entry here. Again, the baseline is if a complaint is submitted on March 7th and we recognize that it's the date for tolling the statute of limitations, regardless of whether a letter of abeyance is issued or how long that abeyance lasts, which we are working to shorten. it's the date that the complaint is submitted. Every complaint, if you've noticed, is stamped with a received date, and that's what we go by. So, and I also, just on a separate matter of what Josh was saying, you know, I interpret on the motivating factor standard, I interpret the Human Rights Act as applying a motivating factor standard under 2.2-3905, number 6. It says, except as otherwise provided, all these bases are based on a motivating factor for the discrimination being a motivating factor. I agree that we have no idea whether the courts are going to adopt the burden shifting with which we're so familiar.
So, Christine, let's talk about requesting a right to file a complaint letter. Now that the courts are pretty much, many of them have said that that's what is required. How does one go about obtaining that letter from you? What's the best practice, and when can an individual request such a letter?
The best way is just to email our civil rights email and request a notice of right to file civil action. If you don't hear from us, follow up, you know, in a week or two. I mean, we are issuing those pretty expeditiously at this point. We've at first it was just kind of the office didn't know what to do with it when I got here, so we're issuing those pretty expeditiously. And also, we try to accommodate people if they say, "Look, I already had to file my complaint with other statute of limitations requirements. Can you issue this in quick order?" I'm sure there's someone in the audience that has been accommodated that way. We try to do that, but right now we issue them pretty expeditiously, you know, within a week, I think. Correct me if I'm wrong. If you haven't received yours within a week, you know, email me.
Your inbox is going to be blowing up here, I think.
I know.
Shortly. Let's move back to practice for Fairfax County Circuit Court. I want to start with discovery. Judge Oblon, may a plaintiff serve her discovery, let's say the interrogatories, the request for production of documents, maybe deposition notices, with the summons and the complaint?
Yeah, our rules provide for that. And that's not a Fairfax County rule. That's the Supreme Court of Virginia rule. If you file your complaint with the discovery at the same time, you extend the period of time that a responsive pleading is due, but you also have the advantage of getting your responses much sooner than you would otherwise. Frankly, I don't see that come up all that often. I of course see the cases in the context of motions to compel, and I usually see motions to compel based on discovery that's issued after the complaint's been filed. So that seems like what most people are doing, but there is a mechanism so that you can file with your complaint the discovery.
And if there is a discovery dispute, let's say, and the parties, one of the two parties has to file a motion to compel, what's your advice on making that the most compelling, making the argument that was compelling for the judge that picks up that file on motions day?
Well, to make it most compelling, you certainly want to hit the judge between the eyes with the issue, and you want to make it somewhat easy to understand and follow. If you are going to be objecting to every single interrogatory and every single request for documents, then that becomes a very big steak to start eating. Instead, if you can batch your concerns in groups, so if you know that there are a number of interrogatories that have the same objection or the same legal principle at stake, batch all of those together and say, this is the issue, the uber issue that we want the judge to decide. And here is the interrogatories, requests for productions of document that fall under this category. And if you break it up by categories, that makes it easier for a judge to digest, and of course, easier for you to win. Also, go all out in working with opposing counsel. Fortunately, we don't see a huge amount of motions to compel. And that's because we do have such good counsel on both sides who will diligently and faithfully work together to try to narrow the requests or try to work out their disputes themselves. If that doesn't work, many judges, I know I do it all the time, will refer motions to compel to conciliation. And conciliation is a process where we have volunteer members of the Fairfax Bar Association who will agree to listen to the motion to compel and make a recommendation. And usually that solves the motion to compel problem, because a lot of times if you've got a tie, you just need someone who's independent to hear both sides out and say, hey, look, you really don't need to push this one forward, or you're asking for too much, you're asking, you're denying too much. And just having that third party can help you just get over that hump. And so embrace the conciliator program. It really is effective.
And does the judge then, if it does go to the judge after that, does the judge learn of the conciliator's recommendation prior to the motions hearing?
No. The judge only knows that conciliation failed or conciliation was successful and it's now to be removed from the docket. So you can work with the conciliator confident that the judge is not going to be affected by the fact that you went to conciliation and it didn't work.
Got it. And any discovery dispute motion, is it subject to the 5-page limit?
Yes, it is. And by the way, the 5-page limit, in addition to what I said about how the judge has got 20 to 30 motions, and if we had unlimited briefing, that would be a pretty unwieldy project. Keep in mind there is an advantage to some of the rules that provide particular chafing, I know, among the bar, including the 5-page limit, the 15-minute limit on argument, 30 minutes total for your motion. And that is, we've got only 15 judges for 1.2 million people in our circuit. We're the largest circuit in Virginia. And if we didn't have rules like this, then one of two things would happen. Either one, it would take years before you'd get a case to go to trial. And instead, we get our cases to trial within a year in almost every circumstance. And then number two, you're pretty much guaranteed that your judge has fully read your briefs and has done research behind the briefs, read some of the cases you cited that are key. And so you'll have a very well-prepared judge. So when you go and make your oral argument, you'll know that the judge is not just skimming your briefs, but has really done a deep dive. And that would not be possible unless we had some of these limiting rules. And then the third advantage is that by limiting your brief real estate and your oral argument time, it naturally helps litigants focus their argument on that which is most important. And it actually makes your briefs and oral arguments more effective. So there are advantages to it also.
And then let's say that one has multiple motions at the outset, let's say a plea in bar and a demur, maybe even a motion craving oyer. Are those three separate motions that need to be heard on different Fridays? Can they be consolidated? How does that work?
No, we separate them out. We've got a local rule that I guess Virginia does not technically have local rules. We have preferred practices and procedures that are permitted by the state code. But we do, by our local preferred practices and procedures, have a policy of one motion per case. And if you want to have more time, or you want to put multiple motions on for a single day, you need to get special permission for that by calling into counter control. We have counter control every morning at 8:30. No appointments necessary. You just have to notify the other side within 24 hours you're seeking a counter control. And of course, you've got the Supreme Court rule that you have to meet and confer before taking anything to the court with the other side. But you can go to counter control and ask for two motions that are so related that they are functionally the same motion. And you may be able to get a counter control judge to sign off on that. But as far as a demur and a plea in bar and a discovery dispute, no, those will almost always be separated into three separate motions days on three separate Fridays.
Thank you. Bethany, let's turn back to discovery for a moment. What are 3 or 4 types of evidence that you're trying to secure in every employment discrimination case?
Sure. So, I really like to focus on getting complete discovery responses as I can to my interrogatories, my request for production of documents, ahead of the deposition, because the deposition to me is sort of the ultimate piece of discovery. I tell everybody I love employment law because it deals with people. I love meeting people, learning about people. What do people do all day? There's so many interesting stories that come out of employment law. And so for me, the deposition is my favorite part of discovery. Whether it's, taking the deposition in particular, getting to be the one to ask the questions, but also defending depositions and just hearing what everybody has to say. But for me, it's definitely taking the deposition, just learning about people and just kind of what makes them tick. Trying to get as complete of discovery as I can leading up to that. A lot of the cases I deal with, of course, people are seeking compensatory damages. We want to get, medical records that would support that. I do a lot of defense of disability discrimination. I've done a lot of workers' comp defense more earlier in my career, but a lot of just that type of evidence that I'd be able to really ask the deponent about in the deposition, but as well as, employment reviews, performance evaluations. Those are the things I like to talk to the deponent about, but really just kind of get a good sense of, how this person's going to present as a witness to be able to evaluate that for the client and the case heads to trial.
Josh, you really like requests for admissions as a discovery tool. Tell us how you use them.
I tend to think requests for admissions can be very useful to narrow the issues. I think some of this comes back to how you draft your pleadings. There are people who like, for perfectly good reasons, to draft sort of long numbered paragraphs, multiple sentences, and really tell a story. We tend to draft complaints that have fairly short numbered paragraphs, 1 sentence each. And if you get a denial or a partial denial in one, I think it's really useful to come back with some admissions and try to narrow down what exactly is being denied, which is much harder to do if you get a flat denial on a 3 or 4 sentence paragraph. But that is something that we like to do, and I think it's very useful.
Thank you. Judge Oblon, we have another question from the audience. When ruling on a demur, do judges apply a notice pleading or fact pleading standard?
Well, gosh, I guess it's a little of both. You have to set forth facts to support each element. Now, the facts aren't intended to be a novel. You just have to have just a small sampling. But you have to do both. You have to list your cause of action, and you have to have a couple of facts to support each element.
Christine, tolling agreements. Does your office recognize tolling agreements? Let's say the parties have tried to work something out. They've come to a tolling agreement. Does your office recognize those agreements staying, if you will, the statute of limitations?
I'm hesitant to answer that just because it would depend on the matter. So,
okay, let's move to summary judgment. Josh mentioned summary judgment. It's an important part of the practice in federal district court. Judge Oblon, on what type of issues are motions for summary judgment normally considered and granted in Fairfax County Circuit Court?
Almost never. Just take your experience in federal court with summary judgment and just keep it in federal court. I wouldn't mind having the federal system for summary judgment that you have, but we just don't have it. And the custom in Virginia is that when a case gets filed, it's going to trial unless you can resolve the case before then. As far as summary judgment, the way you can make summary judgment work, and I guess in the 6 years I've been a circuit court judge, I think I've only seen 3 or 4 motion of summary judgment be successful. Using requests for admissions, very valuable. As we've already mentioned in this seminar, the use of depositions in summary judgment is not allowed under our rules in the context of employment law cases, because you have one side who's not a business, the employee. So what you can do is take Josh Erlich's strategy of requests for admissions and get really good testimony in depositions, and then fire off a request for admission to lock that down, and then file a motion for summary judgment using the request for admission as the basis for the fact not being in dispute. But other than that, it's tough sledding, and pretty much assume that even filing the motion for summary judgment is just a total waste of time and your client's money.
Let's talk about pretrial matters. There are no pretrial conferences or statements in Fairfax County Circuit Court. How are pretrial matters like motions in limine handled, Judge Oblon?
Motions in limine are held on our same Friday motions docket as would be any other motion. And what you want to do is really think hard on what your motion in limine is, what issues you really need to keep out so that you don't draw a mistrial. I mean, those are the ones, because you can't come on successive Fridays practically without wasting all of your client's money on motions in limine for several discrete factual disputes that can be decided at trial. You need to eliminate those very few and rare issues that just the mention of them creates so much prejudice that you're going to draw a mistrial. Other than that, the judge will be able to decide during the trial whether certain evidence is admitted or not. That's just part of the process. And so I see a lot of lawyers, usually from the larger firms, come in and try their case effectively by motion in limine. And we just don't have that effective process in Fairfax for that. And you will wind up wasting all of your Fridays, and you still won't be able to get all of the answers in. But our motions in limine is a normal Friday motion practice.
Judge Oblon, what is term day?
Term day is when our chief judge will go ahead and schedule all of the cases for trial. If both sides are represented by counsel, you don't even have to have term day. You can go on our online scheduling system, OSS, and with the opposing side, go ahead and see all the available trial dates and go ahead and pick your date. For those people who are either have a party that's unrepresented or they just don't know about the OSS, I suppose, they will go into the cattle call of term day when we get to the point practically where chief judge is looking and saying, well, I've got all these cases that have been filed and haven't been scheduled for trial. So we just need to get these things scheduled so that we can make sure we get all of our cases done after a year of filing. When you're either at term day or on OSS, a critical decision you have to make is how long is your trial going to be? And on that, do a bit of a discussion with opposing counsel to try to figure out, and I know it's early on, but you can have a general idea about roughly how many witnesses you're going to need, and try to think through how much time you're going to need. A day effectively is 5.5 hours. And obviously you've got to split that time with the other side. So when you're making your time estimate as to how long the trial will be, don't just guess at 1 day or 2 days, because then when it comes to trial and you find that you need 5 days, you don't have that time. Our courts are just too busy to just take cases and extend them past the time estimate. So if you need a week, ask for a week. If you need a day, that's fine. You just ask for a day. But if you ask for a day and you really need a week, you're going to be very disappointed.
Let's talk about voir dire. How is voir dire handled in Fairfax County Circuit Court?
In Fairfax and every court in the Commonwealth, voir dire is lawyer-driven. And so unlike in the federal practice where you submit perhaps like suggestions to a judge, and I know some federal judges don't even want your suggestions. In Virginia, we don't pre-screen your voir dire questions. You come in, and after the judge has gone through some statutory voir dire questions to eliminate the main questions of bias, then each of the lawyers in turn, first the plaintiff, then the defense, get to address the jury and ask questions voir dire. Keep in mind that if you want to be within the range of expectations as to what almost every other litigant is doing, expect to have an hour for your voir dire. If you're going over an hour, you're now an outlier and you are gumming up the works, and the judge is going to get annoyed at some point. So recognizing you have about an hour to ask questions without being harassed, put your 5 most important questions right at the top. Make sure that those get asked without any problem. And then when you're asking questions, ask questions that are narrow enough so that you get the information you need without blowing up the entire panel and wasting all of your time. For example, if you ask, are you or anyone close to you or anyone you've ever known been an employer? Well, everyone's going to raise their hand. And then you're going to be listening to how, some distant cousin in another state who you never talked to used to be an employer. And that's just information that you don't need, you can't use. And now you've wasted some of your time.
Is the hour, is that per side?
Yes. Yeah. Each. And again, there's no rule on that. I'm just making an observation as to what all of, I do a jury trial once a month, and that is, an hour, sometimes it will go to an hour and a half, but if it's very rare for me to see voir dire on one side going longer than that. And when you are, you're going to start getting, you're going to get some pushback at that point. And the pushback is rightful, because the entire voir dire process is not to educate a jury panel, serve as an opening statement, be an opportunity to move your case forward. I know all those are strategies. I certainly did it when I was a trial lawyer, but that's not what the purpose of it is. And a judge is required to keep it to the purpose, which is to determine whether there's actual bias in a panel member.
Moving back to our questions for a moment. First one for Josh. Josh, are there any scenarios where you would prefer filing a discrimination complaint in the Eastern District of Virginia, Federal District Court, instead of in Circuit Court?
There's a handful of answers, right? One is, if we're going to get removed anyway, we might as well just file there. I'm sure Bethany can speak to this as well, and Scott, your experience, but if there's a way to remove to federal court, largely for the summary judgment reasons, these cases always get removed. So related to that, if we're in one of these ambiguous areas where the law is not settled, we may want to stay out of state court and might want to just be in the Eastern District rather than risking a ruling on something that we just don't even have the capacity to evaluate. And then there are, specific areas of law where the state and federal law has evolved differently. Constructive discharge can be quite different in state and federal court. So that might give us a reason why we want to be one place or the other. And the last thing is that because of the removal issues, if you're filing in state court and intend to stay in state court, you are effectively going to have to waive the federal claims. If there are federal claims, you just cannot bring them and stay in state court. And, that is a tough client decision to make when you're talking about walking away from viable claims because you prefer a venue. So all of those factors go into it.
Next question for Christine. Does the Virginia Office of Civil Rights have a formal mediation program?
Well, I don't know what is meant by formal mediation, but my office mediates complaints. We have experienced mediators in other sections of the office, so that we can refer a matter to them, and that the individuals that will be, if mediation breaks down and a matter is going to be investigated within the Office of Civil Rights, that's not the same person. But we have mediators within the Office of Attorney General that we use. Sometimes might be a particularly complex matter, or for other reasons that should be farmed out. We will sometimes do that.
Judge Oblon, on the 5-page limit for motions day, if a party files a demur, a 1-page document, as its first responsive pleading, and then the party later wants to file a brief in support, is the brief limited to 4 pages?
No, but keep in mind that the judge, in preparing for the motion day, is only going to be reading the memorandum in support of the demur. The demur itself, which really should just be "we demur" and just briefly state your reason, cannot be used to add on to your 5 pages. So don't think that by filing a 10-page demur that now, you've tricked the system and you now have 15 pages because your memorandum is 5 pages within the rules and your demur had no page limit. It just that never works, because the judge is only going to read the memorandum really deeply. But here's an important point. Let's say there are some circumstances, and there are cases where we do have parties where you really do need more than 5 pages. You can get that. You just have to call counter control at 8:30 with the process that I've already told you, and ask the counter control judge for permission. And areas where that gets granted most frequently are areas where you have a large number of counts in the complaint that are all being demurred to. So if there are 8 counts, fraud and inducement, business conspiracy, tortious interference, the usual cast of characters, and everything's being demurred to, well, yeah, the judge will recognize this person's going to need more than 5 pages just to mention each of the causes of action. And so there is a safeguard and a backstop.
We are ready for final thoughts. Bethany, I'm going to begin with you. Final thoughts for us.
Oh, wow. Well, I've learned a lot today, and I really appreciate the opportunity to be part of this panel. I've taken tons of notes. I've learned a ton. But final thoughts, this is an exciting time to be practicing employment law in Virginia. And I think just continuing to be a student of employment law in Virginia, the law is ever changing from the time that I know we spoke about speaking on the panel until the time of speaking on the panel. There have been so many updates coming through with the case law and the things we've talked about here today. So exciting times in Virginia employment law.
Bethany, thank you. Josh.
I agree with Bethany that these are exciting times, and if nothing else, we have a lot more options than we previously had, and it is a complicated question, I think, as to whether you want to be in state court or federal court and the ramifications of the decision that you make. But it's good to have more options, and I'm looking forward to what's coming.
Josh, thank you. Judge Oblon.
When I was in private practice, I was the managing partner of a law firm that, as part of its practice, did employment law. And as a circuit court judge for all of my tenure so far, employment law has been almost inexistent. And so I welcome the opportunity to have more exposure to employment law cases, and welcome everyone who has not yet had the opportunity to bring their employment law case into Fairfax County, and look forward to your case and look forward to the challenges.
Christine.
Thank you again for allowing me to be a part of this panel. I would just tell people to keep an eye on the amendments that are floating out there. We didn't get to discuss those, but there are some creative proposals out there that have pros and cons. And we are all saddling our horses as we ride and interpret the statute. The Attorney General represents all Virginians, and we really take our role seriously to serve the public. And so if you haven't, so please reach out when you need something to me, and we are here to serve you.
Amanda.
Well, I wanted to just chime in here when I heard the court talking about, Judge Oblon talking about, filing things and docketing and your trial dates. Here, any of those of us who practice in Loudoun County know that we do have a significant backlog in our docketing system. And so it is really important from a practice pointer, if you're docketing something in Loudoun County, to make sure that you are giving yourself the correct number of days, and that may put you out a significant amount of time. But our courts will actually remove matters from the docket if they think it's going to take more time than you've docketed it because of the problems that we're having, for which we need another judge, right? That's really the only solution. So I will toss that out there for anybody who's doing cases in Loudoun. And the other thing that I think is important is that our judges do 40% criminal, 40% domestic, and 20% everything else civil. So if you have an employment case out here, they probably don't know a ton about your subject matter. So remember that part of it is making sure that the judges are aware and educating. And even if you maybe think that that's something that's, I'm a domestic practitioner. So, I don't always give the judges all of the statutes, but also all of them came from a criminal background. So they don't necessarily know my work. They're not necessarily going to know your work. So don't be afraid to educate a little bit, even if you feel like they should already know it.
Amanda, thank you. Bill.
Well, this is basically an entirely new and still evolving area of law, it sounds like. So it sounds like keep apprised of those legislative updates. I know one thing as a former prosecutor and current defense attorney, always listen to Judge Oblon. Thanks, Scott.
Paul.
Thank you to the excellent panel and for organizing this. And I guess my plug would be, as all the uncertainty and changes in this law is happening, lean on your colleagues in the plaintiff's employment bar. A lot of us are at small firms or even solo practitioners, and that's where organizations like MWELA and VHRA can be such a powerful resource to have. So thank you.
Thanks to Judge David Oblon, to Christine Johnson and Bethany Ingle. A special thanks to Josh Erlich, who organized this webinar for us. Thank you to Amanda Stone Swart, to Bill Johnson and Paul Falabella, and our co-sponsors for today's program, the Loudoun County Bar Association, the Arlington County Bar Association, and the Virginia Employment Lawyers Association. Mark your calendars for the Metropolitan Washington Employment Lawyers Association's next webinar in conjunction with the Maryland State Bar Association, Navigating Baltimore City Circuit Court in an Employment Dispute. That's on Tuesday, April 9th at 12 p.m. Eastern. For all of our programming from the Metropolitan Washington Employment Lawyers Association, you can find us at www.mwela.org. Thanks for joining us today.